Hello and welcome to today's webinar. Thank you very much for taking some time out of your lunch to join me. My name is Claire-Elaine Arthurs. I'm a property litigation partner with Gunnar Cook. As well as being a solicitor, I'm also a CEDA accredited mediator and a strategy consultant. So I deal with a very wide range of property matters. That comes from managing risks on new transactions, helping facilitating new deals, and also resolving disputes when they do arise. Now, over the years, I've worked with a large number of portfolio managers, and one of the things that's had the biggest impact on their businesses has been shifting from a reactive to a proactive way of management. Now, what do I mean by that? By that, I mean giving things some thought in the beginning to save an awful lot of hassle down the line. And the benefits of this approach are significant. What it allows people to do is to anticipate the workflow in their business. So rather than it being all hands on deck when something has gone wrong and continuously working in peaks and troughs or always being on firefighting, it means they can actually manage their workflow. It also means they can anticipate the staffing needs as well in advance. It avoids a lot of the issues that can lead to disputes, or it minimises them at the very least. It helps people keep control, and because of the fact that the management is proactive, it's going to save costs in the long run, both in the way in which you're managing your portfolio, but also in the way that you are dealing with any disputes or issues as they arise. And in the bottom line then, that's going to maximise the profit of the business. So that's where we're coming from with this webinar series. So what I'm going to be doing over the next few months is I'm going to be doing 4 short sessions covering a wide range of topics. I'm going to be covering some of the key areas of difficulty that I see property managers come across on a daily basis. Now, due to the length of the sessions and the breadth of the topics I'm covering, I'm only going to be summarising issues. But if you do want any further information on any of the issues that I touch upon, then please do feel free to email me. The list I've come up with isn't exhaustive. The intention is just to start you thinking about some of the things that you might be able to do when you're managing your portfolio that are going to be able to make your business run more smoothly and also help you to avoid disputes. It may be that quite a lot of these things are already within your processes, but there might be a few hints and tips there that you pick up along the way, I hope. If you have any questions following this webinar, my email address is on the final slide, and I welcome anybody who wants to email me or give me a call to talk about anything in more detail. So what are we going to be covering in this first session? So this session is called Start as We Mean to Go On. And as Plato said, the beginning is the most important part of the work. And that's ever the case when it comes to commercial leases. But unfortunately, what tends to happen is that people will be so keen to get the deal done that the detail sometimes isn't there. And it's only when something goes wrong further down the line and they pull the lease back out of the bottom drawer of the filing cabinet that they discover it doesn't say what they hoped it would. So what we're going to be focusing on today is looking at what you do right at the beginning of the lease that can make your life easier throughout its term. So we'll be talking about heads of terms, what should be in them, and how does that translate into the lease. Looking at some of the key dates, what are they, and have you actually put them at times that are going to work for you? How do we deal with the minimum energy efficiency standards, and what's going to happen with the government's climate change proposals going forwards? We'll briefly touch on insurance, schedules of condition, look at some management timetables, so these are things in addition to the key dates that you should also be considering, and then we'll finish by looking briefly at deposits and guarantors. So starting with heads of terms. Usually, this is what gets passed across to your commercial property transactional solicitor. You'll give them a note of the address, you'll tell them who the tenant is, what the term is, maybe tell them a bit about the break, the rent, possibly a guarantor. Most commercial property solicitors are lucky if they even get that level of information. Then what happens is they are left with their precedent lease to contact the solicitor on the other side and start negotiating the detail. Now, the drawback from having this approach is that you have to remember that neither of the solicitors have seen the building, they're not familiar with it, and they're certainly not going to be the people that are managing it going forwards. So what happens is you send your heads of terms across, the two solicitors do the best they can to go through the detail. It can take quite a long time because they're generally going backwards and forwards and coming back to you for lots of instructions. You get very frustrated with how long it's taking, and then towards the end, you get to the point where you're saying, come on, just carry on, it doesn't matter, just get the deal done. Actually, you're setting yourself up for a very difficult time, whereas if you gave some more thought at the stage when you're looking at the heads of terms, you could make that process faster and your lease could be tailored to your needs more specifically. So what should you be thinking about when you're in your initial negotiations? First off, you want to be thinking about the property description and the permitted use. So what's actually going to be included in the demise? You need to make sure that your plans are detailed. Now, if the plans are of a larger property, or if there are certain bits of detail on there that you cannot see clearly on the plans, it is worth making sure that they're in the description. Let's be clear about what is in the demise and what's outside of the demise. This will avoid a number of disputes down the line with your tenant. The other thing to think about is permitted use. Can the tenant actually use the property for what it wants to use it for? It seems fairly obvious, but we come across issues all the time where actually the planning permissions on the property aren't quite in line with the tenant's use. You also might want to talk to the tenant about their long-term plans for the property. It may be that they're taking it on as an office block for now, but what if they want to put retail in on the first floor in the future? Finally, have a think about parking. Parking is one of those areas that is ripe for disputes. If you have anything other than straightforward parking that is simply going to be within the demise for the tenant to use, then you need to be very clear as to how it's going to be dealt with going forwards during the term of the lease. Thinking about payments, rent. You need to have a think about when do you want rent to be paid? How regularly does it need to be paid? It needs to work for you and the tenant. It's not written in stone that things have to be on a specific quarterly day. It's not written in stone that they have to be the first of the month. You can put into your lease something that is going to work with your processes, because it may be helpful for you if you have a large portfolio for your rents to be coming in at different times of the month so that they can be checked by staff as they come in. Have a think about how you're going to be dealing with insurance rent. Ideally, you want that reserved as part of the main rent for the purposes of enforcement under the lease. Service charges, what is and is not going to be included. Your general provisions for service charge will have a cover-all approach to them, but that means if there is anything unusual or specific about the building that you are dealing with, you could then be facing an argument as to whether that does or does not come under service charges. It is much easier if you specifically mention that to your solicitor to make sure it's included in the lease at the beginning, and then they can have a catch-all clause as well. But this will mean that you're not going to be having the arguments with the tenant going forwards. In terms of rent reviews, you need to have a think about what mechanism is going to be the easiest for you to use. What's going to be the most beneficial, but what also are the costs going to be involved if there are any arguments about that. Have a think when your rent reviews are as well. Now, obviously, time isn't of the essence for the majority of rent reviews, but if you think about it, if you've got a rent review that perhaps is happening at Christmas or right in the middle of August, if time then becomes of the essence, that's going to be a very difficult time of year for you to have staff coverage to pay any attention to dealing with that. So you need to have a think about when these rent reviews are going to be coming in. Insurance, again, who's covering what? Are there any special provisions that are needed? If there is specific additional insurance that is needed for the type of property or for the way in which the tenant is using the property, then that needs to be in your lease. Repair and alterations. You might want to have a think about what level of repair is going to be needed. Are you going to have specific requirements? Do you want the property back at the end of the lease with perhaps an EPC rating of a D above to save you from the minimum energy requirements that we're going to talk about in a moment? Do you need to be thinking about alterations? It may be that you don't want the tenant to be coming back to you all the time for every minor alteration. So you may want a list of things that you agree with them at the start and say you are happy for them to do X, Y, and Z, provided they reinstate at the end. That saves them coming backwards and forwards to you, but keeps control of the property. For any more significant alterations, you might want to specify again what information you require from them in order to make sure that that's a smooth process and it saves work on your side. In terms of work that's for statutory purposes, so for example, fire regulations, disability access, health and safety, minimum energy standards, it helps if it's clear in the lease as to who is going to be responsible for paying for any upgrades that are required by statute. Thinking about subletting and assignment. First of all, are you going to allow subletting? If you are, is it going to be part or whole? Are there going to be minimum provisions with regards to the 1954 Act? What permission process do you want to go through? Are there any minimum requirements that you want in terms of what you would find acceptable for a subtenant? Bearing in mind there is a possibility that if this tenant falls away, you might end up dealing with the subtenant directly. In terms of assignment as well, how would you like the assignment process to be managed? Are there minimum criteria you want to be dealt with in there? Looking at the end of the lease then, so your yield up provisions, practicalities. So when are your break dates? When is the end of your term? Is this going to be a good time for you to be taking back the property and remarketing it? Is it going to be a good time for you to have staff having to deal with perhaps going around doing inspections, dilapidations, showing new parties around and so on? So think about putting these at times of year that work for you. Also, what do you want to be done at the end of the lease? Do you want the property redecorated? In which case, do they need to be coming to you for permission a month, 2 months beforehand? Think about practically what you want to do at the end of the lease. In terms of breach, there will be some things already in your lease in terms of self-help remedies. So the opportunity to go back in and do works if the building's not being kept in repair and so on. But it might be worth you also considering whether an arbitration clause or a mediation clause is going to be helpful for you, because this could save a lot of costs down the line and save you having to go to court. It's becoming more popular, and given that the courts these days are insisting in the majority of cases that one of the first steps is that the matter goes to mediation, it would be more sensible in a lot of cases for the issue to be dealt with at mediation before you as the landlord incur a hefty court fee. In terms of costs then, who's paying for the costs under the lease? Now, most landlords, the answer is the tenant, but you need to make sure the tenant really is paying for anything coming up under the lease. Are they paying for the permissions? If there's a breach, forfeiture, court costs, have these all been reserved? And have you reserved costs not just for the legal fees, but also for any professionals such as surveyors or valuers and so on that you might need to call in to deal with any aspects of the lease? Now, the reason that's important is because if you bring a claim generally through the courts, the most that you can recover, if fully successful, is around about 70% of your costs. If you're recovering your costs on a contractual basis because they're in the lease as a reserved clause within the lease, that means that your ability to recover costs goes up significantly and you can get your costs back on an indemnity basis. So what that means is that if your costs are reasonable and you're successful, you will get the majority of your costs back rather than just 70%. Thinking about options as well, as I said before, have a think about when your breaks are. What do you want to do with regards to renewal? Do you want to be having discussions for the tenant to put you on notice if they're going to leave at the end of the term? In terms of sales, do you want to give the tenant an option of first refusal? There is a code as well for leasing business premises that you might want to be aware of, and I will send it round a link to that with the recording of this webinar. The code isn't binding, but it is being referred to more frequently these days in transactions as being a general indication of what might be considered to be reasonable. And certainly when matters come before the court in terms of interpretation or in terms of the reasonableness of the landlord when approaching a matter, then they will have reference to the Business Premises Code for England and Wales 2007. So it's worth bearing that in mind if there are any disputes coming up at the negotiation stage. Okay, thinking about the key dates then. Commencement and the end of the term. These are the obvious ones. End of the term you need to know about, even if you have got a contracted out lease from the 1954 Act Security of Tenure provisions. Because if you allow that lease to then continue for a further 6 months, there is a possibility that your tenant is going to obtain security. So you need to know when the end of the term is coming up, because that's going to change the status of your tenant. If the lease is within the 1954 Act, then that's obviously when those provisions will also kick in. One of the things people forget, though, is having given permission for the subleases on properties, you also need to be aware of when those leases come to an end. Because it may be that you deal with the head lease, but then if the subtenant has been allowed to hold over, they may too start acquiring rights under the 1954 Act and so on. You need to have a think about rent reviews. Now, as I said before, these are not necessarily going to happen at the date of the rent review, but you don't want these to be left for a significant period of time, because obviously once the review takes place, the market is growing at present, so it's likely that your rent is going to go up. You're then going to be looking to your tenant to pay the difference between the rent that they have been paying and the uplift for the period over which you've been negotiating. If you leave that for a significant period of time, then that can be a very large sum of money. And the problem that you have with that is that then interferes with your tenant's cash flow. And that's when that causes problems within the relationship between landlord and tenant. So ideally, you want to be keeping an eye on when rent reviews are coming up. And if you are going to be operating them, you should be thinking about doing it relatively near that date. Repair and redecoration. You need to have a think about dealing with repair and redecoration during the course of your lease. The reason for this is because you can enforce the repair covenant during the life of the lease to ensure that the property is brought up to the condition that you want it to be kept in. As soon as you reach the end of the lease, you've got a cap on how much you can recover in terms of dilapidations, and that's capped at the diminution in value of the property. So instead of looking at the cost of the repairs, what you are looking at then is the difference of the value of the property in repair compared to the value of the property in its state that it's currently found in at the end of the lease. That can be significantly less than the actual cost of putting the property back into repair. It doesn't take into account the fact that it's going to be much more difficult either for you to find another tenant while the property is in disrepair. During the course of the tenancy, you have the opportunity to serve notice on your tenant. That notice you can then threaten to either end the tenancy, or more effectively, if you've got the correct clauses in your lease, you could threaten to go in and do the works if the tenant doesn't do it themselves. This generally means that your property is kept in better repair and you have fewer dilapidations to deal with at the end of the term. Options you need to keep an eye on. As I said, break options. You need to be thinking about when renewal might be coming up, thinking about options to purchase and rights of first refusal. There might also be other special events that are specific to your property that you need to note. And it may be fairly obvious, but you don't just need to note these specific dates. You need to actually make a note so that you have reminders coming up on some form of system, at least a month, possibly further in advance, to make sure that you are dealing with the matters as they arise. I can't count the number of times that I have had last-minute panicked phone calls from clients when they've realised a break option is going to be exercised tomorrow and they don't know whether they can get things served in time, or something's come out of the blue from a tenant because they'd forgotten that that provision was in the lease. So you need to give yourself a bit of notice so that if you need to do something with your rent review or with a break option or so on, you've got plenty of time to take your time and get it done properly. Okay, minimum energy efficiency standards. The Energy Efficiency Private Rented Property England and Wales Regulations 2015 came into force for commercial property on the 1st of April 2018. So from the 1st of April this year, you cannot grant a new commercial tenancy with an EPC rating of E or below an E without getting yourself into potential issues with regards to the minimum energy efficiency standards. Going forwards, any commercial property leases that are carrying on after the 1st of April 2023 will also be caught by these provisions. So you're looking for having commercial property rated at least an E or above. But the thing to bear in mind is that the government have said that they are looking to raise that standard going forwards. So it's an E at present. That's got the potential to be brought up in the future. There are some limited exemptions for properties such as listed properties, and there are also potential exemptions there if the works, for example, are not going to repay themselves within 7 years. If you do not adhere to these regulations, so if, for example, you are renting out a property below an E, then what you will find is you will find yourself facing a fine and having your name published on a public register by the local authority. The fines at present for a breach that's lasted less than 3 months are around up to £50,000. More than 3 months are up to £150,000. And the register, as I said, is public, and it's on, and your name is on there, showing that you are renting or attempting to rent substandard property for as long as the local authority deems it to be relevant. And considering the lack of administration with many local authorities, that could almost be permanent. So what can you do to deal with that? Well, the first thing to think about is the EPC that you've got on your property up to date, and is it actually accurate? When the government first brought out EPCs, they didn't have enough assessors, so they made qualification to become an EPC assessor a very basic task. Unfortunately, what that means is that there was an influx of very basically qualified assessors into the workplace, people who had no background knowledge with regards to the structure of properties, or in fact with regards to the energy efficiency of the properties themselves. They're just ticking boxes on a form. And this has meant that a lot of the properties within the UK currently have EPCs which do not accurately reflect the property itself. So what you need to make sure is that your EPC has been done by somebody who actually understands the background to the property. You also need to have a think about assessing, if you are going to be doing works, what combination of works are going to be best for you, how are you going to most efficiently bring your property up to standard if works need to be done. And if you are looking at some of these exemptions, such as a 7-year exemption, you are going to need to get that type of advice. Now, there's an easy way of doing that. There's a company that I've done some work with, which is Arb & Co, who, again, I will send you round a link to them along with the recording of this webinar. Arb & Co have got software which is backed by qualified surveyors. They can assess your EPC to see if it's accurate. They can also look at simulations for different types of works, and they can also help you with dealing with the evidence that you might need for some of the exemptions and with getting those registered. They've kindly agreed that for attendees to this webinar and for those who are listening to the recording, they are going to be running a webinar on minimum energy efficiency standards, giving you more details. And again, I will send that round with the recording of this webinar. So obviously I've only touched on this topic today, but it is something to bear in mind. Now, this may be coming up at the beginning of you renting the property, but the other thing that I'm seeing the EPC issue come up with is at the end of leases as well, which you may need to be aware of. There are tenants out there who are getting energy performance certificates done towards the end of their tenancies on their property that they are in occupation of, because if it is substandard and the works need to be done to bring it up, then that may supersede a significant proportion of the dilapidations works. So it's worth bearing that in mind. It's also worth bearing in mind that when new subtenancies are granted, they may also trigger the requirement for an EPC on the property where there hasn't been one previously. Or if you have one that's becoming out of date, you may need to renew it, and that could have an impact. But in terms of your minimum energy efficiency standards, the government has said that they do plan to review the process, because obviously this has come down through EU legislation at present. Now, post-Brexit, it's going to be in with everything else to be reviewed, but what they have reiterated is that there is a commitment to climate change. So while they're going to review it, I would not expect that this is going to be the last we've heard about looking at the energy efficiency for commercial properties. Looking then briefly at insurance. In terms of getting insurance as a landlord, it is worth noting that not all policies are created equal. A lot of the additions that were previously taken for granted, such as your legal cost cover, are now no longer being included as standard within many policies. So you need to make sure that you're clear on exactly what's in the policy and what additional extras you may want. Legal cost cover is one of those that I would advise you to have, because it can be significantly, it can be significant if you find that you've got a problem that isn't covered by the insurance legal costs. In terms of the insurance policy that you pick as a landlord, you don't have to accept the cheapest policy. You accept a policy of a reasonable price that is fit for what you need it to cover. So it may not be that you go for the cheapest policy on the market, it may be that you decide to go for one. As long as the costs are in the same ballpark, that's perfectly acceptable. You should also note that you can get tenant default insurance if you're particularly concerned about a tenant defaulting on the rent or not adhering to the terms of your tenancy, although that can become quite expensive, and it's not necessarily something that you can recover from your tenants. Schedules of condition. Now, it depends on how you're going to deal with repair of the property as to whether you want a formal schedule of condition within your lease. Obviously, if the obligation of the tenant is to bring the property back into a state similar to that in which it was let to them, then that's going to be particularly beneficial. If that is the case, then you need to ensure that the same level of detail that would be put into a terminal schedule of condition is put into your initial schedule. Because on many occasions, people have done a very, very brief schedule of condition at the start of the lease, when they then come to compare at the end to say, well, this work needs doing, that's not been redecorated, this needs to be repaired. The problem that you've then got is that there is no comparable from the start of the lease. So the devil really is in the detail. Even if you are not going to put the repairing covenants by reference to a schedule of condition, it is still worth having some kind of photographic record or other evidence of the condition of the property when you let it. The reason for this is that you may find yourself in dispute over dilapidations about what would be considered a reasonable condition for a property of that age. If you are able to show that from the beginning of your tenancy to the end, there has been a significant decrease in the condition of the property, then you've got a much better argument as a landlord for your dilapidations. Whereas if you don't have that evidence, you could just be saying that it's conducive with a property of that age. So it does help you with regards to your dilapidations to make sure that you've got that evidence at the beginning of your tenancy. The management timetables. Obviously, you've got your key dates, but in addition to that, you need to have a think about regular inspections of your property. Now, I'm not talking about you having to be in there every month. Regular with regards to what's sensible depending on the term of the lease. But what you shouldn't be doing is handing over the keys at the beginning of the tenancy and then never visiting the property until after the keys are handed back at the end. Because what you're going to miss during that time is potential repair issues. As I mentioned earlier, they're a lot easier to deal with during the term of the lease if you keep on top of them. Unauthorised activity, so things like unauthorised subletting, unauthorised alterations. If you can notice these as you go along, they're a lot easier for you to deal with and to manage. Third-party activity. Again, if you don't visit the site, you won't necessarily notice that next door has moved the fence over and taken over part of the car park, or that there's a development going on at the back which may have an impact on your freehold, or that indeed members of the public are cutting across part of the property to the extent that it may be considered that they've got some rights established over it. These are things that a tenant coming to the property may not necessarily be aware of, but they are things that a freeholder agent or estate manager is much more likely to pick up on, but only if you are there on a relatively regular basis to see it happening. It keeps communication open with your tenant as well. So if you pop in, if they've got any problems, it encourages them to raise them with you in a timely fashion. It also means you've got some idea about what their plans are, and you've got that communication with them to be able to sort things out with them informally, rather than it coming as a shock to the system when you finally get in touch with them. And then the final thing to consider is your tenant viability. If you go around their office and the majority of the desks are empty and it doesn't look like much work is going to be done, then that should be sending off some alarm bells. If there are problems with the business, this could potentially mean that there are going to be problems for you down the line. So when they look like they're thriving and things are being looked after and they're busy and the environment attains to that, then that's great. But if you go around an inspection and you see things aren't quite how you might expect, that could prompt one of those conversations with the tenant. In terms of what you should be doing back at the office, have a think about monitoring the payments coming in. Are they coming in on time? If they're progressively getting later and later and later, that's going to suggest that there is a problem coming through there. Keep an eye on who's paying the rent. If suddenly another party starts paying the rent, that could spell trouble for you. That could mean that they've had a pre-pack administration, or it could mean that the tenant's gone altogether and that somebody else is now in occupation. The key thing to monitoring things in the back office, and this is part of why I suggest you may not want all of your rents coming in at the same time every month, is that that means that you can have prompt action to deal with issues before they escalate. Coming on then to the last couple of points, so deposits. Deposits is a form of self-help remedy. It's a pot of cash that's there as against any breaches of the tenancy. But what you've got to bear in mind is that it is only a limited sum. So it's not going to necessarily cover all the rent arrears that they're allowed to accrue. It's not necessarily going to cover all of the repairs that need to be done at the end of the tenancy, particularly if they've got that Section 18 diminution in value cap on them. So it's only going to be limited in how useful it can be. It should also only be used as a last resort. Quite often what happens is people will draw down on the deposit immediately when there is a default in rent. The problem you then have is your rent has been paid, so you have lost all the remedies associated with your unpaid rent, and it's much easier actually to raise a claim for unpaid rent as well. What you now have is an issue with getting the money back in to top up the deposit, and the problem with that is that's a lot harder to force a tenant to do that, and you also don't have your remedies there to help you with it. So really you want your deposit to be kept up until the end of the tenancy so that it can be used as against the outstanding breaches at the end of the tenancy, rather than having to use it during the course of the tenancy. If you do have to dip into it, then it's very important that you make sure it's maintained, because again, you've then got that buffer for the end of the tenancy. Final point we're going to be thinking about today then is guarantors. So, guarantors, they can be very, very helpful because it gives you another party to have on the hook to ensure that the terms of your tenancy are going to be adhered to. But you've got to have a think about who the guarantors are. So first off, who are they? If they are a shell company with no assets, then it's unlikely you're ever going to be able to enforce anything against them because they don't have anything for you to enforce against. If they are a company that's in a different jurisdiction, so say it's a parent company in, for example, South Africa or somewhere where you may have issues with jurisdiction, that again is not going to be a great guarantee, because even if you do get a court order against them for you to recover sums or to force something to happen in terms of the lease, you're not going to be able to enforce it against them particularly easily. So you need to have a think. If you've got a guarantor, it needs to be somebody, either an individual or a company, who has assets and stability, and you need to make sure that they're in a jurisdiction that you can actually reach. You need to have a think as well. Are they somebody that you would want as a tenant? If things go particularly wrong with the business that is going into your property, there is a potential that you could ask your guarantor to step in. If they step in, would you want them as a tenant? And then the other thing to think about is guarantor reviews. It's fantastic if you have a guarantor at the beginning of the tenancy that you have done all the checks on, but if your tenancy then goes on for a number of years and you haven't checked on a relatively regular basis that that tenant is still operating, if they're a company, are they still live, do they still have assets, you need to make sure that your guarantor is still valid. And you perhaps want to consider that if anything happens to the guarantor that makes them invalid on a set set of criteria, that you have the ability to substitute in a new guarantor as approved by you. So you have to have a think about guarantors as you go along. We'll go into them in a bit more detail in our later parts of this series. So that's everything for today's session. What we're going to be doing in the next 3 sessions is looking at some things that happen during the term of the tenancy themselves, and then also looking at the end of the tenancy. So the next part of this webinar series will be at 12 o'clock on the 2nd of October, and we will be dealing with, in that session, looking at rent collection and arrears, repairs and dilapidations, service charge recovery, general breaches of the lease, what happens with guarantors when you have breaches or you want to vary the lease, and also looking at third-party rights in relation to the property. So it remains for me to thank you for tuning into this webinar. I hope you found it useful. If anybody does have any questions or would like any further information on anything that I've touched on today, then please do either give me a call or drop me an email. My details are on this slide. Thank you very much.